The Supreme Court has ruled today, and we're anticipating, of course, in the next, really, I guess it's going to be the next week. We're going to hear the Hobby Lobby case, the National Labor Relations Board case, the Coakley v. McCullen case, where we provide where the buffer zones provided for people entering into family planning clinics, abortion clinics, all that is in the offing. The Supreme Court ruled unanimously today that police need warrants to search the cell phones of people they arrest. Now, we spoke about this, I believe, the issues at this case some time ago, but essentially, it has been the practice of police prior to the advent of smartphones. When one was arrested on any charge, it could theoretically be jaywalking. The police have the right to search incident to arrest. When a person's lawfully arrested, they can search the person. The issue now with smartphones is that police would have the ability to actually not just say, okay, you have a phone, but to turn it on, I guess theoretically ask for the code, go into the phone, get all sorts of information that was not available to them in the past. There were two cases that made up this ruling. The first case was Riley v. California. Arose from the arrest of David Riley. He was pulled over in San Diego in 2009 for having an expired auto registration. Police found loaded guns in his car. And then, on inspecting his smartphone, entries they associated with a street gang. They ultimately found in this phone information that led them to a shooting. There was a second case, United States v. Worry, which involved the search of a call log of a flip phone of a guy named Worry who was arrested in 2007 and charged with gun and drug crimes. The New York Times filed a brief supporting Riley and Worry, in which they argued that cell phone searches would compromise news gathering. I guess presumably you could arrest a reporter for jaywalking and then dig in and find out who he's been in contact with, whether it was criminals or leakers or whatever it was. The Justice Department said the old rule should apply to the new devices. And the arguments against was simply that the phones that people carry today are like mini computers and therefore deserve more protection and a higher level of judicial scrutiny in terms of the validity of searching those. In other words, I think you need a warrant now if you want to search someone's cell phone. So that is the ruling that impacts whether or not cell phones in this day and age can be searched incident to an arrest.